For the clients, particularly on the plaintiff side, tonight is opening night.
Mm-hmm.
And even for the defense side, where perhaps they have seen similar situations over and over and over, there are no two that are exactly identical. There are differences. And among those is that you're dealing with different plaintiffs, different personalities, and you can't expect the same exact approach to work equally effectively with every human being. You have to be sensitive, you have to be observant, you have to be nuanced in dealing with the particular situation and circumstances of the day.
The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome to Mediator in the Middle. This is your place to peek behind the curtain of what a mediator is really thinking. I'm your host, Abe Melamed, a litigator turned mediator. In this series, I, along with world-renowned mediators, will offer you, the clients, the lawyers, the parties to mediations, tips and tricks on how to be more effective in mediation and ultimately get yourself the best result possible. Thank you for listening. Please enjoy. So welcome back to Mediator in the Middle. I'm your host, Abe Melamed of Melamed Mediation, and we are really excited to have a special guest today, Jeff Kichaven. Jeff is one of the preeminent mediators, maybe in the country, if not the world, and has many, many honors, many recognitions, many accolades. I think some of the most significant are being a past president of the Southern California Mediators Association and also a distinguished fellow of the International Academy of Mediation. Those are two, I think, of the main, preeminent organizations. But you've taught at Harvard, Pepperdine, the American Bar Association on topics about mediation. You've been doing this for 20 plus years. I hope you don't mind me aging you a little by saying that, but we're really excited to have you here.
I didn't grow all this gray hair for nothing. Go ahead.
Fair enough. But look, we're really excited to have you. I think the listeners will gain a lot from your perspective. Anything about your background or bio that I missed that you think is important for them to know?
Well, let's just get into the conversation. People can judge for themselves. And thank you. Thank you for the very kind and generous introduction. Thank you for inviting me onto your podcast. I'm very proud to be here. Thank you.
I appreciate that. It's really nice to hear from some of the most seasoned mediators out there, and we've had some great guests, but you have some unique perspectives that I'm hoping the audience will get. And so let's focus on the topic just on the broad level. The way that I always try to structure this is start very broad, get more narrow, and then end a little bit more broad. So the topic today for the listeners is approaching every mediation like it's nothing that you've ever seen before. A quote I saw, I think it's on your website, is that lawyers often tell you it was unlike any other mediation that they've attended. And your response is, well, it's been different from any mediation you've ever done. I think a lot of people tend to forget that it may seem like the same fact pattern. It's a new case. It's a new mediation. It's new parties. And I think that that's an important perspective for the lawyers who are representing clients in mediations to have. So starting just from that broad perspective, anything you wanted to say, any thoughts about that concept, Jeff?
Abe, I do think that customizing every mediation is critical to the success of the mediation. And I mean that not only in terms of getting the case settled, which we try to do if there's any reasonably possible way to do, but also in terms of the satisfaction of the participants, the lawyers and their clients as well. We don't want people just to get a settlement. We want people to get a settlement with which they are happy. Mm-hmm. Yes, happy. And by that, what I mean, Abe, is that they're better off with the settlement than without it, and they recognize it as such. And if we can get people really to understand what their options are, the strengths and weaknesses of the different choices before them, and help people make decisions that are best for them, almost all the time cases will settle, and they'll settle in a way that leaves people satisfied and happy. Mm-hmm. So I think that with those as our goals as mediators, we can work toward processes and results that achieve those goals.
I think that's a great perspective. And, it's funny because I think you and I are aligned in this, but a lot of mediators out there talk about, let's get to the worst case, but the best worst case you can get to, or a good mediation results in both sides leaving unhappy. But I think it's not that. I think, like you said, the parties should be happy with the outcome. They should recognize the value in this versus the alternative, the BATNA, as we always say. So I think that's a great perspective.
Look at it this way, Abe. You got some diplomas hanging up behind you. I assume you went to some fancy schools and worked very hard to get impressive degrees from those schools, right?
Sure. Yes. Some fancy schools, some less fancy too.
And then you worked hard in your legal career and otherwise to get to the point where you are, right?
Yep.
Did you put in all that hard work only to have a career in which your goal was to make people unhappy?
No, definitely not. And it certainly was not the intention in shifting from litigation to mediation. It's to help people be happy, help them get to peace,
Well, to help them get to a point where they are better off than they were before. Peace is a pretty ambitious goal. To turn around a truly miserable situation to where there is peace from 9 to 5, that's a pretty tall order. The way that I try to think about it is that we are removing one obstacle to people being at peace with themselves and hopefully leading happier lives. Because oftentimes the pendency of litigation consumes people. It's the intangible. It's very hard to measure. But boy, people sure know when it's there, and they sure know when it's missing, that sense of peace.
Yeah.
And if we can remove an obstacle to that sense of peace from people's lives, then we put them in a much better position to move forward, improve their lives, increase their own happiness, and perhaps ultimately, if they're a little lucky about it too, yes, they will achieve that sense of peace.
Yeah, I think that's exactly right. And, one of the things that I think is really the focus of this podcast, I think it's going to be really helpful, is to offer some tips and some experiences for the lawyers themselves who represent clients. I think it's not uncommon for a lawyer to go in thinking they have the same case in front of them that they had last week. Recent anecdote I had, and I'll be curious if you have any recent that you can think of, but I had a case where it seemed pretty straightforward. It was a government entity. There was some issue with sewage and the liability wasn't contested. The damages was in dispute. And the plaintiff's lawyer had come in having mediated several of these cases within the week and just sat down and kind of got into it. And it's every regular case. And it wasn't until we were really into the process that it became clear that there was a critical question about whether the person installed some toilet at a certain time. And suddenly it was a scramble for, well, can we find a receipt that he pulled a permit for this toilet? And we did. And it made a huge difference on the case. But it was something that I think would have been much better to have long before the mediation. And that's something we've talked about in past episodes about a lot, is pre-mediation phone calls, front loading the process. We did a whole episode with Lee J. Berman. But I think that was just a prime example of the lawyers themselves need to come in with the perspective of, this is a new case. I need to look at this with fresh eyes. I need to think about this as if it's a new client, new case, new facts. So any similar anecdotes, examples you can think of where a lawyer not recognizing that made a difference, or maybe in the reverse where it's clear a lawyer approached it that way and that made all the difference?
Abe, you remind me of an interview I once heard with the great Broadway performer Nathan Lane. And Nathan Lane at the time was starring in The Producers, one of the greatest hits in the history of Broadway. And he had been doing the same songs and the same jokes and the same show night after night for month after month. And the interviewer asked him, how do you keep it fresh after all these performances? And Nathan Lane said, I keep in mind that as far as tonight's audience is concerned, it's opening night. And I think that's what we have to remember, that even though we may have seen, as mediators and as lawyers, we may have seen any number of cases involving whatever sort of fact pattern it is, certain kinds of traffic accidents or defective products or insurance policy wordings, whatever it may be. For the clients, particularly on the plaintiff side, tonight is opening night.
Mm-hmm.
And even for the defense side, where perhaps they have seen the situation, similar situations over and over and over, there are no two that are exactly identical. There are differences. And among those is that you're dealing with different plaintiffs, different personalities, and you can't expect the same exact approach to work equally effectively with every human being. You have to be sensitive, you have to be observant, you have to be nuanced in dealing with the particular situation and circumstances of the day. So when we start with that mindset, we have a big leg up.
Yeah, I think that's a great point. And I'm actually curious to pivot into the psychology of the situation, what your experience has been and what you would recommend to lawyers. I'm writing an article right now, an academic article with a PhD in psychology from California about attachment bonding and mediation. A trend I saw was the parties, the way they react and interact during a mediation is indicative of their attachment style. Are they avoidant or are they anxious? Do they need to tell you everything or do they not look at you? And these are some of the things I try to look for, pick up on early on in a mediation to assess how I'm going to deal with that person. But I think it would be helpful for the lawyers themselves. They know their client better than anyone. They've met their client hopefully numerous times before this mediation. They know them, understand them. So when I have a pre-mediation phone call, that's a question I always ask is, can you tell me about the temperament of your client? What do they need through this process? Do they need catharsis? What's their psychological makeup? And I think that more lawyers should be thinking about this and giving a tip to the mediator. Hey, look, this is what my client is like. So what's your general practice? Is that something you focus on in pre-mediation calls or you think is important?
Abe, I think it's critically important to focus on the personalities of the people involved, exactly as you mentioned. So many times there are tensions and even estrangements between lawyers and their own clients. Mm-hmm. Sometimes a lawyer has worked very hard to bring a case to its full value, whether you're on the plaintiff side or the defense side. And yet the clients are not satisfied because the lawyer cannot make everything the way it was before. The lawyer cannot make the plaintiff to live without the injuries they have suffered in a personal injury case, to live with that, to restore the glowing business opportunities that people thought they might have had in a commercial case before things went wrong. And you'll get clients who will be demanding of lawyers more. We want things to be just the way they were before, even though things can never be the way they were before. You can only move forward. You can never move backward. And lawyers sometimes get frustrated with clients, just as doctors sometimes get frustrated with patients.
Yeah.
So when lawyers find themselves in that kind of situation, the mediator is in a rare, really a unique position in that we both have the skills to help and we have the motivation to help. Mm-hmm. So a lot of what we do in many mediations is we help lawyers communicate better with their own clients to understand what are the limits of litigation, what kind of results can it produce, and then have conversations about how do we fill that gap between what the legal system can produce for someone and the way it all was before. Mm-hmm. And sometimes, Abe, we want to talk to people in terms of bringing to mind situations in their pasts when they had dealt with seemingly hopeless situations. And yet somehow they drew on internal resources to get themselves through those tough situations. It could be loss of a job, loss of a loved one, a death in the family, loss of a romantic relationship or a marriage, loss of financial opportunities. How have people drawn on internal resources to get through those prior challenges? And if we can bring those circumstances to mind, it helps people summon those same internal resources again, so that once again they can get through the disappointment that they may feel with certain aspects of the settlement.
Yeah.
And the result where we know this litigation is going, if people can draw on those internal resources, then they can be happy with the settlements, even if they're disappointed in the financial term of the settlement, because they know the settlement leaves them better off than they otherwise would be.
Yeah, I think that's a great point. And I think drawing on those prior experiences is a really critical tool that a good mediator will have in their toolboxes to help those people draw from those same sources of inspiration or courage that they may have used in the past. So, one of the things that I think is really critical for the lawyers to do going into the mediation, I'm curious what your experience has been also, is to go through those facts and prep with the client, not just for the psychological value or to maybe start setting some of those things up, set the table, so to speak, for the mediator to come in and help draw out those experiences, but also to go through the facts themselves. I had a mediation, I would say it's about a year ago at this point, where at a certain point in the day, the plaintiff's attorney said to me, "Wow, this case actually seems like a much better case than I thought it was. Thanks for bringing out all these facts for my client. I didn't even realize." And it actually became an impediment settlement. It got settled, but it was almost like I had done a disservice by helping gather the facts. But it's frustrating as a mediator, I think, to find that a lawyer, and it's not to say that they're not doing their job, but I think that the way that you think about a case coming into a mediation as a litigator is different than the way you need to think about it in a mediation. And that's one of the pieces of advice I give is try to think like a mediator before you get to the mediation table. Try to think, what would the mediator want to know? And the question I always ask is, give me all the ammo that you can give me to use with the other side to move the needle. And so I think that when attorneys, plaintiffs and defense attorneys, litigators refocus a little bit from that perspective, not on why do I win and why is this positionally my win, but more on, well, how can I help you help me get across the finish line? I think it makes all the difference. What's your experience? What do you usually advise the lawyers in advance of the mediation to prep them to gather all those facts?
Abe, the gathering of facts for lawyers to make sure they're totally mastered the facts, they know them in detail. Yes, it's very important for lawyers to know that, because those issues do often come up in mediations. To bring it back to what we were discussing in terms of client satisfaction and the relationships between lawyers and clients, lawyers may ask themselves, what are my client's needs with respect to these facts? Does my client have a need to hear everything rehashed in great detail? Does my client have a need to address their emotional reactions to some of these facts? Does my client have a need to listen either to what a lawyer or a client has to say on the other side? And this leads into the subject of planning for the mediation in those advanced telephone calls.
Mm-hmm.
The mediator, what I like to do, at least when I have those calls, and I like to have them after I've read the briefs, and I like to have them separately with each lawyer.
Yeah.
I like to talk about the client's personality, the client's demeanor, how the lawyer gets along with the client, how the lawyer's getting along with everybody in the case, the lawyer's perceptions of how the other lawyers and clients get along with each other. We then start to talk about planning for the mediation day and what we need to do at the beginning of the mediation day to get the ball rolling in the right way to address the needs of the individual people in the particular case. So sometimes we'll talk about the need for a joint session. Do we need to have direct communication in this case to illuminate certain factual issues, to talk about people's emotional reactions to some of those factual issues, to talk about some of the practicalities of settlement, be they insurance coverage or other things? is there a need to address some of these questions directly, not just through shuttle diplomacy by the mediator?
Right.
Are there one or two key issues, and there generally are one or two that stand out above the others, that are keeping people from making progress in the negotiation? So, discussing with the lawyers what will be the structure of the mediation day. Do we need that direct communication? And I love to talk to lawyers about the relationship between those joint sessions or direct communications and the caucuses which follow, and the tremendous opportunities we can create for lawyers to impact their clients' thinking.
Mm-hmm.
Subsequent caucuses, if we've had a good, focused, effective joint session before that quote unquote initial caucus takes place. Should we elaborate on that, Abe?
Well, yeah, I think it's actually a really critical point, and maybe let me set it up a little bit. But we've had some discussions in previous episodes about joint sessions, joint lawyer sessions. We did an entire episode with Gig, which was a phenomenal episode about having the lawyers come together. But what I think is the most significant takeaway from that point is that the lawyers need to be thoughtful about this question, and I think that there are a lot of mediators who've done away with joint sessions, who feel strongly about it. My practice, and I'm pretty sure it's your practice, is to basically say, what does this case need? It's a case-by-case analysis. And I've had some plaintiffs' lawyers tell me, I need that joint session with all parties present because I need my client to feel a little bit of the uncomfortability it's going to feel when they're in a courtroom. And I've had others say it's just going to drive my client away from resolution. It's too emotional. And so I think that that's the most critical piece in my mind, is have that conversation with the lawyers. But more importantly, for the lawyers out there listening, think about these issues going into the mediation. Have those conversations with your clients in advance. Talk about it with some colleagues and say, is this a case that needs that joint session? Is this a case where we can skip it? Is this a case where we should skip it? But to be prepared to have that conversation with the mediator. And if the mediator doesn't ask you up front, if they don't have a pre-mediation call, for you, the lawyer, to be affirmative, go call that mediator and say, hey, look, in this case, I think we need this. So that's my view. What's your view on that general concept?
Abe, you couldn't be more correct about the need to explore the individual circumstances of every case and customize your processes. The kinds of cases that I do are typically business-to-business cases. A lot of them involve intellectual property issues, including patent cases.
Mm-hmm.
A lot of them involve insurance coverage issues on commercial policies, business-to-business issues. A lot of them are professional liability cases, legal and accounting malpractice. I do some cases which are consumer to business. Most of them are business-to-business cases, and we have seasoned business executives, experienced negotiators on both sides, along with lawyers who are themselves sophisticated negotiators. And there can be a tremendous benefit from having a joint session, not what we used to call a plenary session. 30 years ago, when I was taking mediation training, there hadn't been a lot of time for reflection on this. The mediation training was basically community mediation training, landlord-tenant, neighbor-to-neighbor, those sorts of things that you would see in the community justice centers. And the community mediation training was transported wholesale into the commercial legal world. And in the cases that you would get in a small claims court, for example, the mediator would more or less parachute into the dispute, be there in the hallway of the courthouse or a room in the courthouse, and people would come in for mediation. The mediator would have no prior briefing, no telephone calls. What's this case about? Tell me, what do you think? What do you think? What else could you do? You didn't know anything else about the case.
Yeah.
So that was transported into the commercial world. And we were taught, sit everybody down and say, well, please tell me about your position and tell me about your position. And then clients add your interests and concerns, and then you tell me about your interests, needs and concerns, values, and all that sort of thing. And lawyers would do the only thing they knew how to do, which was to give the kind of opening statement that they would give in a courtroom or an arbitration.
Mm-hmm.
And it would have its flamboyant elements, its antagonistic and sometimes bombastic elements to them.
Sure.
And it would cause these great conflagrations in the mediations. People would lose their tempers, yell at each other. Well, gosh, who wouldn't if you had a chance to do it?
Yeah.
And somebody saying all these bad things about you. And that, I think, is why in commercial mediation, people got away from the joint sessions altogether.
Mm-hmm.
And was just shuttle diplomacy, a mediator going back and forth between the different rooms, different ends of the hallway. People wouldn't see each other, perhaps never see each other during the day. And I don't think that's particularly good, because what happens to clients in that kind of proceeding is it's very hard to generate satisfaction or happiness on the part of the client. The client feels no investment in the result because the client has had no hand in shaping that result and fashioning the result. They're just sitting there like a stone. And in terms of emotional extremes, Abe, the client who sits there like a stone, emotionally speaking, is not that much different than the client who's flying off the handle and yelling and screaming. Neither is engaged in the mediation in a constructive, productive way.
Right.
So what can we do to try to re-engage the clients? And there's a different way to construct a joint session in a commercial case, and that is through the preparation process. If we can isolate one or two keystone issues, perhaps we can agree we're going to have a limited joint session, direct communication, where we address just the one or two issues that are really keeping people apart.
Mm-hmm.
And that way, the joint sessions tend to be shorter, they're more focused,
Yeah.
they're less likely to get out of hand.
Yeah.
And then when you go into the caucus after that, you can really have the magic happen. Because then there can be a conversation, not an argument, a conversation between the mediator and the lawyer in the presence of the client, which is very well designed to change the client's mind or allow the client an opportunity, I should say, to consider settlement opportunities seriously, which had not been considered seriously before, perhaps not considered at all. Imagine a caucus, Abe, where I'm the mediator, I come in, we've had a joint session to talk about what is the appropriate measure of damages, out of pocket or benefit of the bargain. That's an issue to discuss without getting people too riled up. We come into the caucus and I say to you in the presence of your client, Abe, we were in that joint session there, and you heard what your opposing counsel, William Jennings Bryan, had to say about the issue. He was urging the benefit of the bargain measure of damages, and he had a number of points about that. He had 3 points. Number one, well, I wasn't too impressed with point number one, but point number two seemed to make some sense to me. And point number three, I was pretty curious about that one as well. So let's talk about number two, Abe. What did you think about William Jennings Bryan, point number two?
Yeah.
And then we can talk about it. We're having a conversation and understanding that Mr. Bryan is also a very skilled advocate, might have some chance of prevailing on the points he makes. When we have that kind of conversation in front of your client, the client may think, well, let's think about this. Contrast that with the kind of conversation we have if there has not been a joint session. Then I, as the mediator, look much more like the sponsor rather than, shall we say, the narrator of—
You're not the messenger.
Opposing counsel's argument. Right. You're no longer the messenger.
Yeah.
You're discussing it. So without the joint session, you are the messenger. You are the message.
Yeah.
You're coming in and you're saying, Abe, I understand you're urging the out-of-pocket measure of damages, and you understand that the other folks are urging benefit of the bargain. I've got their brief here. Now, they've got 3 points in defense of their position, in support of their position. Number one, Hadley versus Baxendale. Now, Abe, you know, Hadley versus Baxendale says right here, holds this and this and this and this and this and this. What about that, Abe? And then you're going to say to me, well, Hadley versus Baxendale does not apply at all, and it should be distinguished, and blah, blah, blah.
Yeah.
All of a sudden, you and I appear to be arguing about the effect of Hadley versus Baxendale on this case. Your client is listening to what now looks like an argument. Anytime it looks more like an argument and less like a discussion, it's going to have less of an impact on your client.
Yeah.
Because your client understands at some level, you, their lawyer, are there to defend them, to be their champion, the zealous advocate, the fiduciary, 100% on their side. And the mediator, whatever our ethical duties are not the same as yours. We are not the zealous advocates, the fiduciaries. We are not 100% on your side.
Yeah.
So if anything appears to be an argument between the mediator and the lawyer, in the client's eyes, the lawyer is always going to prevail. And it's a lot harder in an argument type communication to help the client see that there may be other possibilities there for settlement, which perhaps they should be considering.
Yeah.
So I want to make this point loud and clear. The true benefit of going through all this elaborate preparation and sometimes enduring, the direct communication joint session is because it sets up that precious first caucus afterwards, where you can have a conversation rather than an argument about the key issues in the case and maximize your likelihood of having a positive impact on your client's thinking and hopefully moving in the direction of settlement.
Yeah, I think that's a phenomenal point. It's very well said, because it's what I hear from a lot of the lawyers when there isn't a joint session. You know, I want to feel like you're doing the same thing with the other side. I want to see that you're pushing the other side as hard as you're pushing me, or, you know, something like that. And, you know, when you have that interaction, it's because they haven't seen the role that you might play out, which is why, even if it's not going to be with the parties in the room, but at least bringing the lawyers together. And then the lawyer has the ability to sit down credibly in that caucus, that first caucus after, and say, look, I just sat with their lawyer. He made this point and this point and this point. And you become, as the mediator, become, you know, somewhat of a confirmation. Yes, that's what was said, but it's not just coming from you. So I think that's critical. I think that's a great point. And, you know, the trial advocacy version of that is, they always taught, and it's something I always implemented in cases I tried, was you lead the jurors right up to the point of the conclusion, but you don't ever hit them with the conclusion over the head. You want them to invest in reaching that conclusion themselves. If they haven't invested, then you've just given them that outcome. So I think that that's a critical point for the parties and for the lawyers to be thinking about and preparing. You know, have these conversations in advance. Make sure to set the table for the mediation itself. So, you know, which is a great pivot point to something that I think you'll have a lot to say about, and that is prepping the clients to receive bad news. So that's something that we as the mediators need to do periodically. It's a question I always ask in a pre-mediation phone call. Can I pull you out from your client and let you know that this is a concern I have, or does it need to come in front of your client? Is your client going to be suspicious of me pulling you out? Is there a way for me do I need to sugarcoat this, or can I just hit them over the head with it? Are they a sophisticated client who can understand it, or do they need to see you advocate a little bit? You know, what role do you need me to play? That's a question I will always ask as it relates specifically to delivering bad news. But from your perspective, what's the most important thing for the lawyers representing clients in mediations to know about that, to think about in that respect?
Abe, all of those points are very important. And if we talked longer, we would come upon many other aspects of client personality which would be very fruitful to discuss in those pre-mediation calls.
Yeah.
One aspect to keep in mind is trying to figure out what the client needs to come to their own conclusions. What's missing from the conversation? And by asking the lawyer what their client needs to get from where they are to what might be a better place in the negotiation, you'll get all kinds of helpful information from lawyers who understand that this is really what we're about. This is an important aspect of what we're about in the mediation. And Abe, as much information as we get in advance of the mediation, we still have to be observant in the mediation.
Yeah.
Because people's moods change as the day goes on. People show up differently. You don't know what's going on in somebody's home life or personal life or financial life that may be affecting how they show up on the day of the mediation. So one thing that I like to do when people first come to the mediation, whether it's virtually on one of the online platforms or in person, and about half my mediations are back to being in person these days.
Mm-hmm.
I don't just escort people out of the lobby or waiting room and into a joint session. I like to talk to each side first.
Yeah.
For a variety of reasons. I may know the lawyer pretty well. Chances are I've never met the client before.
Yeah.
And I want the opportunity to establish some rapport and some chemistry with the client. I also want to be able to form my own opinions about how can I relate to this client. I know the lawyer may have said this approach, that approach will work, won't work, and that all may be perfectly valid. And at the same time, there may be things that I see in the client's personality or things about my own personality, which might make one approach or another better or worse in my own dealings with the clients. I like to ask the clients in those preliminary meetings at the very beginning of the day. I might say something like, I've read the briefs. I've had a chance to talk to your lawyer. I think I have a pretty good understanding of what the case is about, and I'll give some indication that I'll say some things that'll show that I do know what the case is about.
Yeah.
And then I'll say to the client, what else do I need to know to be most helpful to you today? I'll usually ask it just that way. And I'm very curious. I learn a lot from the clients, no matter what they say or don't say. Many times a client will say, no, not really. I think that's pretty much all been covered. And then it's very important for the mediator and the lawyer to pause and to take a few deep breaths. Because many times a client will say, no, I don't really have anything to add. And then if you give them 10 or 15 seconds to think about it, they'll think of something.
Yeah.
And they'll say, oh yeah, I just want to emphasize, or I just want to make sure you really understand XYZ. And that feedback from the client, the ability for the mediator to establish some rapport with the client early on in the day is very important, because at the end of the day, lawyers are going to call upon mediators to help them encourage the client to pay a little more, take a little less, do this a little differently, do that a little differently, in order to get the darn deal done.
Yeah.
Lawyers look to us for that help, and we need credibility. We need some relationship. We need some emotional or psychological capital with that client in order to be effective in giving lawyers the help they need. And if we can spend some time, with the lawyer's permission and with them present, of course, at the beginning of the day, building up that credibility, establishing that chemistry, so that we and the clients feel like, yeah, we know each other a little bit. That credibility and that chemistry, which we have established at the beginning of the day, pays off big time at the end of the day.
Oh yeah, it makes all the difference. I 100% agree. And I think that, the most critical thing is for the lawyers to recognize that and to, assist the mediator in any way possible. The lawyers have done their job. They will continue to do their job throughout the day. The relationship that needs to really be, nurtured in that process is the mediator and the client directly. So I think that the more the lawyers can do to help that process, I think is the better. One more kind of subtopic that I want to focus on, and then we'll wrap up. I don't want to keep you. You've given us a lot of your time. I appreciate it. But one kind of subtopic of all of this is, I find as a mediator that sometimes the best ideas come from the lawyers. Sometimes, I like to think I'm a creative person. It's one of my brands as a mediator, the creative mediator. But at the end of the day, some of the best ideas have come from the lawyers, sometimes even from the parties. And many times it's when you get closer to the end, when you've bridged a decent amount of the gap. And it's a question about how do we just bridge the last little couple of inches. But I found that some lawyers are afraid to speak up, to make those recommendations, to offer those insights, or to offer that perspective or that creativity. That's one thing that I would encourage more lawyers to do is, don't feel like you're stepping on the toes of the mediator. Any good mediator worth their salt is not going to be insulted if you say, hey, Jeff, I really appreciate that, but I wonder if you went back to the other side and suggested this, what they might think. Any good mediator is going to say, that's a great idea. Why don't we give that a shot? So, what are your thoughts, or what's been your experience on that front? Do you agree? Is that a critical piece, making sure the lawyers feel comfortable to play a role, and their clients also? Their clients understand their, finances best. They understand their corporate structures best. They understand what they can and can't necessarily give. So, giving the lawyers that perspective of you can play a role in this too, I think is important. What are your thoughts?
Because we as mediators are always the least knowledgeable in the room, and because it's hard to get somebody to consider new ideas until the old ones are exhausted, then yeah, probably deserves a place on the agenda. You commented a few minutes ago about the important relationship being between the mediator and the client. In a sense, it's important, the relationship between the mediator and the client. The other relationships in the mediation are also critically important. Obviously, the relationship between the sides, we usually call them plaintiff and defendant. Well, that's really important because they have to come to an agreement, agree on the same thing. So that's critically important. And the relationship between lawyers and their own clients.
Yeah.
Lawyers are usually doing a terrific job for their clients. And because the results that the legal system produces are not 100% solutions, we can't make things the way they were before, there's often a sense of disappointment in the lawyer's performance, even though the lawyer's performance may be stellar, because it doesn't make things the way they were before. So for the mediator to be focusing on the relationship between the lawyer and their own client, making sure clients understand just what a good job their lawyers have been doing for them, that there's no logical reason to be disappointed, although there may well be sincere emotional feelings of disappointment. All of that contributes to clients making deals which are in their self-interest, with which they can be happy, and with which their lawyers are fully on board. So we have to keep all that in mind. In terms of the ideas that might or might not be good ideas, there's a lot of questions, a lot of process questions that come in there, Abe. Who is in the best position to convey this proposal or float this trial balloon? Who should be in the room listening? And I know you've mentioned lawyer-only caucuses. I sometimes call them attorney summit meetings, where the lawyers communicate outside of the presence of clients. They may feel some additional flexibility, some ability to do off-the-record informal brainstorming that they perhaps couldn't do in the presence of clients. People might misconstrue it as commitment to a position.
Yeah.
So yes, it is sometimes appropriate for the mediator to do the shuttle diplomacy and shuffle these ideas back and forth between the rooms. When it gets to be much more than dollar numbers, we'll take this, we'll pay that, then mediators and lawyers should consider seriously reconvening for more joint sessions as the day goes on, or having attorney summit meetings so that you can have that spontaneity of communication and you can see and detect people's reactions to it. For a mediator simply to say, oh, that'll never work, as true as it may not be as persuasive as letting a lawyer talk to another lawyer, or having everybody on one side talk to everybody on the other side and float the idea. And then if somebody else says, well, that'll never work, the proponent of the idea can say, well, what are your concerns? To use one of Alex Carter's favorite questions, what are your concerns?
Yeah.
And to flesh it out in that way, because through that kind of spontaneous communication, that kind of brainstorming, well, my gosh, Abe, isn't that a lot more efficient and productive than a mediator going and saying, they said your idea will never work. Well, what are their concerns? Well, I don't know.
Let me go ask them.
Let me go ask. Well, we have these concerns. Well, go tell them that concern number one is silly and concern number two we can deal with in this way or that way. Oh, okay. Yeah. Well, mediator, you may think telling someone their concern is silly is probably not going to work. I better pull the lawyer aside or think of some way to articulate that idea differently. You see, lawyers have become so conditioned to the mediator doing all the work. You know, I sometimes say to people, Abe, here's a critical distinction between good mediation and bad mediation. And it's just as simple as this. In good mediation, the mediator helps the lawyers do the best job they are capable of doing on behalf of their clients. In bad mediation, the mediator does their job for them. It's a bad idea, Abe, because as we mentioned earlier, the lawyers are the ones with the duty of undivided loyalty, the fiduciary obligations, the 100% commitment to their clients.
Yep, the rah behind their position.
And we are not. So the question is, how much authority and responsibility should a lawyer who has a duty of undivided loyalty delegate to a mediator who does not share that duty to their client? Is it fair to the client to delegate to someone who does not have the same motivation, the job of advocating for the client? My answer is yes, there is a place for shuttle diplomacy. There is a place for mediators to be ferrying information back and forth. And there's also a more significant role for lawyers to play than they often are playing in 2023 in how these mediations shake out.
How they should go.
My sense is that it's like any stool. A stool stands on three legs. We have the mediator, we have the lawyer, and we have the client. Each has a role to play, and those roles are different from each other. The mediator should not be encroaching on the lawyer's role, and the lawyer should not be trying to foist their role off on the mediator. The mediator facilitates the negotiation, creates the environment in which the negotiation can take place, creates the circumstances under which people can make those great deals. The job of advocacy belongs to the advocate. And so I would commend lawyers to ask themselves, in given cases, in given circumstances, are they maintaining the proper demarcation of responsibilities? Are they making sure that the mediator is doing the mediator's job? And are they making sure that they are fully discharging their ethical obligations to their client, reserving to themselves the duties and responsibilities which are theirs, and then doing that job and fulfilling their responsibilities better than they ever thought they could before because of the
mediator.
because of the incredible environment that mediator has created.
Yeah.
That's what a great mediation feels like.
That's great mediation. I think that's exactly right. And I think that the point about reconvening a joint session is so critical, particularly in mediations of continuing relationships. A lot of the work that I do now are employment cases, and many times that's a severed relationship. They've been terminated, they've left, they're no longer going to have to play nice in the sandbox. And so it's, when you get to the outcome, it's usually the dollar figure and the handful of other things. But the commercial cases I do, the IP cases I do, in those cases where you have a continuing relationship, you need to get through that big hurdle at the beginning or middle of the day, the most significant piece. But then when it gets to, okay, we essentially have an agreement, we just need to work out logistics and we need to start getting creative about how to do that. I think that's absolutely right. Bring the parties together, let them have those discussions. And you can still play that role as the mediator. You can still play that role as the lawyers, even in the background, to, try to refocus people. Hey, let's bring it back to the issue at hand or whatever it might be. But I think that's a great point, that's what makes it a great mediation, is when you've facilitated that environment for them.
Then the clients see the lawyers doing that great work on their behalves.
Yeah.
Clients understand this person is working as hard as they can and doing a great job. Yes, I'm a little disappointed with the financial result. I'm paying a little more. I'm not getting quite enough. But the other dimensions of the settlement, finality, certainty, elimination of risk, elimination of further expense, and all the rest, the utility of those other dimensions is so great that it outweighs the disappointment that the client feels in the financial term.
Yeah.
Client is happy when their utility or satisfaction is increased, and they give credit for that where it belongs.
Yeah.
To their lawyer.
To their lawyers. Well, I appreciate you taking so much time. I don't want to keep you any longer. The final question I always ask is just, what is it that you love about mediation? What motivates you to get up and do this every day for 20 plus years at this point?
Abe, there's so much, and it's different every day, and it's in a sense the same every day. There's people out there, lawyers and clients, in the middle of litigation. I was a litigator for 15 years, and I experienced a lot of misery during those years.
Yeah.
I experienced the client's misery. I experienced the misery that was created for the lawyers and for the courts and everybody else. And yes, occasionally there is a victory so one-sided and so sweeping in litigation that it obliterates memories of all the negative stuff that happened along the way. But that's a rare circumstance.
Yeah, very rare.
So what keeps me going is knowing that I can create environments in the mediations for lawyers and their clients to get better results, to get them from a better process, to get them more efficiently, more effectively, to create greater satisfaction, to create the opportunity for people to get back to their businesses and back to their lives, to create progress in people's, a result which will allow people to progress in their lives. These are some of the dimensions, Abe, of just helping people. And for me, being a mediator is the job, is the career where I feel I can do the most good, helping other people be happier and lead happier lives. That's what gets me out of bed every morning.
I love it. I think that's a great motivation, and I can see why that would carry through for 20 plus years.
27 years now, Abe. 27 years.
27. That's wild. Time flies when you're having fun.
Amen.
Well, I appreciate it. I really, really, truly hope the audience appreciates it. The expertise and experience you have is second to none. So thank you for taking the time, and hopefully we'll have you on again at some point on another topic.
Thank you so much, Abe. It's been a great experience. I really appreciate it. If anybody has any questions or wants to get in touch with me, my email is my initials, jk@jeffkichaven.com. Somebody wants to give me a phone call, that's great. I'm in the Pacific time zone, Los Angeles, California, so please don't call too early or too late. My cell phone's area code 310-721-5785, and I'm happy to answer any questions that anyone may have. Thank you again, Abe, for a wonderful opportunity.
My absolute pleasure, and I'm going to make sure to link your website as well in case anyone wants to reach out and book you for a mediation. I'm sure the audience can recognize your value. So thank you, Jeff.
Thank you so much.
Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you, and keep calm and mediate on. Thank you.